Good morning, friends. Adab, Sat Sri Akal, Namaskar. This is my 188th video, and this is going to be about a bungalow which was resumed from Jalandhar Cantonment OGB number 63. This was resumed way back in 1934. Now, this is a very interesting story about this bungalow. When I was researching some documents and I was given these research documents by Mr. Seyal from Jalandhar, this case came out during this period. This bungalow owner, Mr. Jagat Singh, actually objected to the government's change in the GLR when it was first being made for Jalandhar. And he objected to the undertaking or writing in it that the land belongs to government. And on that behest, this bungalow was finally decided to be resumed. Now, it's very interesting. Before the resumption, there was a confidential report made. And this report speaks of some amazing materials which is in my hand. And friends, I must share, if we can share such kind of evidences, documents, I can club them for you people with the basic laws from 1773 onwards till 1859. Because after 1859, the Indian Council Act came in being, and that was basically the enactment that all laws now will not be in the form of a Governor General regulation or an ordinance, but there is going to be substantially in coming days, there are going to be laws or acts made. So Journal Clauses Act, TPA Act, Land Acquisition Act. So many kind of acts, Police, IPC Act, all these acts started coming in. CPC came, then later CPC was amended in 1908. Now this bungalow, I have a confidential report with me. This clearly speaks that this bungalow originally, which was called 63, had its number 217. Now, if people in Jalandhar are a little better smarter, they can either decrease the number from 62 to 64, increase from 63, 64, 65. Let's presume 63 was 217. So 64 must be 218 and 62 must be 216. So we can somehow manage to garner these kind of numbers. Now there is a report from the department regarding mentioning these two numbers. And originally this bungalow, it has been said, was originally in favor of Mr. Deccan Floro. Okay, Deccan, Major Deccan Floro. So, well, I really wouldn't be knowing so much because it is very invisible, 1850. He sold this bungalow on 25th September 1851 to Lieutenant W. Graffat. Now, Mr. Graffat further sold this bungalow to Honorable Poise. Now, Honorable Poise means he was either a subordinate judge or what? On 20th November 1851. So, the bungalow is changing hands within 2 months. Further, Mr. Honorable Poise sold it to Captain W.J. Young. This was somewhere in 28th May 1853. Then finally Captain Young, who willed it to his wife Mrs. Young through a court order, the same date of purchase, 28, he gifted it, on 28th May 1853. Now Mrs. Young holds this bungalow till 1930. Now this is very important. And she sells it to Lala Narayan Singh Das on 28th November 1930, as per these kind of records which are available. Here there is a little discrepancy in this record. It says Narsingh Das sold it to Gauri Shankar on 3rd July 1920. So there may be a little up and down, and Gauri Shankar sold it to the present incumbent Jagat Singh. That was in 8th November 1829. So this 1930 sale from Mrs. Young to Lala Narsingh Das creates a discrepancy whether this grant was divided from the original number 217 to another number called bungalow number 63, and there were two separate sales of these bungalows because at that time there were no survey numbers to these. Now the present proprietor Jagat Singh purchased so and so, there is a complete indexing, and this house now known as bungalow number 63, wide appendix F, when the late Special Land Officer of Jalandhar Cantonment, Captain Muhammad Azim, addressed him the inquiries, wide appendix E. Very important, the earliest register of government land held by lessees in Jalandhar Cant, dated 1846, page 73, proves that the site originally belonged to government. Now 1846, and couldn't be 1946, there was no such register which was being maintained under any rule. And then he talks of some page 73, so there may be 1 to 73 pages. So let's forget. And here he says that it was Major Deccan who was originally granted this house. And he erected and sold it further and further. And there was a presumable admission that this was a grant under Governor General Order 179, 1836. So friends, this register becomes very important. And the appendix E, where the Special Land Officer, who's making a kind of a record of rights for Jalandhar Cantonment. So finally, this report is speaking of a para. All the lands comprising in Jalandhar Cantonment were acquired by government on payment of full market value or grant of land in exchange. Wide a submission report, para 2 of acquisition of cantonment lands, a statement attached thereto. And the para ends with that the land is owned by the state. Now, will we call Punjab or Northwest Frontier a state, or Bengal Presidency a state as a whole? So, India was divided in these 4 states. Bengal Presidency state, Bombay Presidency state, Madras Presidency states, and the Punjab Northwest Frontier state. Let's presume it this way, because there was no Punjab, Haryana, Himachal or UP, nothing. We are talking in the period of 1846, 1850. So this is very important. The whole area in Jalandhar Cantonment is state owned, is further proved by the Deputy Commissioner's letter so and so of 1926. Now, acquisition comes in 1926 by the DC of Jalandhar. Annexure C or Appendix C is annexed. Another para that all lands in cantonment belong to so and so and so and so. Same building site number 67 originally granted to Lieutenant Robertson in November 1854, which remained in occupation with Lala Narayan Singh Das for a considerable period, was resumed under the order of Punjab government, wide letter number dated so and so 25 February 1913. So now here, this man Lala Narsingh, his grant was already resumed in 1913. So what was the re-resumption of this bungalow number 63 is very important from Jagat Singh, when he objects to the noting in the first GLR of Jalandhar that land belongs to government or Union of India or statehood of National Frontier, NWF or whatever we could put it. So this bungalow was already resumed, and this letter is also with the annexure report, which is with me, and it clearly speaks of the same doings, that this bungalow was resumed by the orders of the ministry. So when all these kind of things are available, and in 1930 the bungalow was already resumed through the government of Narsingh Das, so what was left then? Did you do partial resumption? So many things have to be discussed out, and then only we can reach to a actual, in 1947 in prior, I can believe and I admit, the catastrophe was to such an extent that no Indian or native could have, objected to the working, but yet, well, Jagat Singh did do. Now this suit is filed when Jagat Singh objects to the amendment in the GLR. 1913, the bungalow is already resumed. The detail is there. Now, when this suit is filed, who's filing this suit? This suit is being filed by the Secretary of State, India. This is very important. So, who is the plaintiff? Government against Jagat Singh. Well, this suit comes up under the purpose jurisdiction clauses, suit under Section 3, Act 13 of 1888, value is fixed, claim of declaration comprising of a survey number 382 forming a site of bungalow number 63. There is a plan attached on west, east, everything. So finally this case comes up for hearing and the adjudication starts taking place. Now when the General Land, where is the cause of action? When the General Land Register was being prepared for Jalandhar in 1930, the defendant, who was an occupier of bungalow number 63, proposing survey number so, disputed the proprietary rights of the government in the land occupied pertaining to the state. It is alleged that all the lands within the limits of the Jalandhar cantonment belong to government and the defendant has no propriety. In the present declaratory suit has been instituted by the sanction of the Government of India. Now, somewhere it is a statehood subject, but who's sanctioning the court case? It's Government of India, 1934. The cause of action, action arose in 1930 when the defendant disputed this title. Now this case continues, and then first issue is made on a very different story. The main issue is the defendant the owner of the site in dispute? Now the onus is again left to the defendant. Is the plaintiff stopped from claiming a title to the site in dispute by his conduct? So the issue of ownership which comes is coming through the defendant has to put it on. Now very interestingly, this bungalow number 63 was mortgaged to the Ambala Commercial Bank from the owner Jagat Singh. So then there was a dispute that why not make the bank also a party in this case. And then there's this report of 7th July 1934 of Niamat Khan, which actually was the special land officer who conducted this entire survey of the Jalandhar cantonment. According to the statement of DW1, a clerk of the military state officer Lahore, the General Land Register was prepared in cantonments in 1930, and that register was prepared from the property registers. We must understand this. Entry at number 217 of the property register for the year 1846 related to the property in dispute. Now here the number comes and it's in a document on exhibit in this case through DW1. So he says, this said register was prepared by His Excellency the Governor General in the year 1889. The property in dispute is entered at number 63, and similarly in 1905 the property is entered at number 63. So maybe the bungalow owner at that time was aware that his bungalow number was 217. So he disputed that the resumption of 217 has already been done in 1913. So what is being resumed? Is 63 being resumed or 217? So there is a proof being flown in that it is 63 is this bungalow which is being resumed of Mr. Sardar Jagat Singh. According to exhibit P1, P2, P3, which are extracts from the different registers, this property is clearly identified, and under section 35 of the Evidence Act so and so it is admissible. Now the Cantonment Code, section 271 of the code, what does that say? 271 is not for private lands, it is again for leases. So you have to understand, everywhere the government is somewhere playing the game that we were not leases, 63 was not a lease, it was an old grant. So this old grant has been put in the lease section. So is my old grant a lease? This is a case in Ambala which was fought by Librans. They presumed that old grant means lease, rent-free lease. There's a different story. Now PW1 Captain Faujdar, who's the MEO, then comes in, he proves these orders and he gets in various codes and all. Now when we move into other things, as held by a judgment, it is coding of 1882, a military cantonment is a designation implies to a locality set apart primarily for military and medical officers, chaplains, soldiers, subordinates attached to the troops and officers of that department. Well, this is a normal statement given in the cantonment manual also. At least where there is nothing to show that it is held by different tenures, belongs to the government, it restricts the rights of a private property within the cantonment. Now, exhibit P4, para 6, the land is given to a person to build under conditions defined therein, and the question raised by the defendant whether compensation for the land was paid by the government was strictly proved by the government. So that means this entire Jalandhar cantonment was resumed. This is what the court is, the defendant, plaintiff is trying to say. Or is he trying to say in 1913 when this bungalow was resumed, compensation was given? Now, we have to understand, what is the government trying to prove here? It is actually trying to muddle you down with some laws. Well, there is a GGO 179, there is no denial about it. What about the subsequent GGO then prior to 1846? There was no GGO which said there is going to be a house property register. It was the 1833 register, GG, Governor General order. So 1846, by which order there were registers being maintained? How grants were being given to Captain Young and Captain Deccan or whoever the names were named in? So all this goes and proves everything contrary to the laws laid by the Britishers itself. Now they were making this GLR in 1930, and many people in Jalandhar, which this entire research book says, objected to the entry of writing that this land belongs to government. So now it was because it was the government was the plaintiff, they had to prove, and they continued proving candidly with the same thought that the officers in 1850, 1851, 53 had taken permissions to occupy lands or something like this. Yeah, even today if you buy a property in Hudda, Pudda or anywhere, you do write to the basic authority that there is a transaction being taken place, so I need an NOC. NOC doesn't mean that this land belongs to Haryana government or Punjab government or UP state government. So these were some kind of vicious doings at that time, and most of the people, got admitted to this fact. Admission deeds, 1934, he doesn't talk of any admission deed. It's a very remarkable story in this case. Nowhere Jagat Singh's admission or anybody prior to him's admission is brought on record. Neither of Gauri Shankar, neither of Lala Narsingh Das, neither of Mrs. Young. Nobody is giving an admission deed. Where are these sale deeds? He says there is proper sale deeds. So there was, as per our CEO's report, prior to 1889, section 32, there were no sale deeds because TP Act was not applicable prior to that. So these things need to be proved. Another case was referred by the government. This is again of 1873 Privy Council of Rawalpindi. So these cases were picked up, and candidly somewhere the bungalow owner was being cordoned to this fact. This property was in Lahore, while a partition deed on 3rd July 1920 registered at Lahore, again transferred to Jagat Singh contractors, and so on. Captain Young, the deal is. So this is how this property was, they show, is getting out. The defendants argued that according to para 6 clause 3 of exhibit P4, there could be no transfer to Mrs. Young until the consent of the officer commanding the station shall have been previously obtained under his hands, and no such sanction is proved to have been obtained. He's right. It is written in the GGO that every time a transaction goes from any army officer to a native or somebody else. So he's very correctly picking up that Mrs. Young, from Captain Young, the wife, when she was inheriting in 1853, where is that permission? So that permission doesn't come. Unfortunately here, the bungalow owner goes to an entirely, his advocate goes to a different thought, and he goes into the thought of an adverse possession. So transfer rights, adverse as the owner, but there are letters exhibit P15, P18 of the agents at late Colonel Young to prove that the property was transferred to Lala Narsingh Das after obtaining proper sanction. The proper sanction was given under white letter number 1800 of 1903. That means 1903 sale, and sales to Lala Narsingh Das from Narsingh Das to Gauri Shankar 1920, and then resumed in 1913. Then again sold in 1929. What is happening? Nobody knows. 30 years old document which does not need to be proved. Same under Evidence Act, exhibit so and so. So these kind of things really matter. Now the bungalow owner or his advocate in 1934 was unable to define old grant. And this is where he moved to adverse possession. Because these documents were showing from 1850 the possession was of the officers or his wife. Let's say even Mrs. Young. Mrs. Young flew into this property somewhere in 1853 and 1934, more than approximately 80 years. And this is where the declaratory suit entirely went against it because of a judgment, Ghaswala versus Secretary of State India, Pune. The earlier two judgments, Privy Council 1888 and 1873, doesn't speak of ownership at all. So guys, we need to understand. We need to, somebody in Jalandhar, get down. Go to the record rooms of the judiciary, dig in this judgment, case number 17 of 1934, get the entire evidence of this file, photocopy it. This will actually extract a lot of things for us, because the GLR speaks of two major things. We are an old grant, we are holder of occupancy rights. Nobody knew how to prove these two things in favor of us. The third thing speaks is against us. That is, who's the owner of the land is Union of India, Government of India, British, or whatever statehood. So friends, we are old grants. We had clearly occupancy rights because occupancy rights meant proprietorship. Thank you. Good day.